Thanks everyone for getting a little taste of case law update in Maryland. And my name's Jack Huskin, and Steve Tregay is here as well. We're the two Chartwell Maryland attorneys doing Maryland comp. We also do Pennsylvania. And since it is Maryland, there's not a lot of case law update. We've said in the past that Maryland, unlike other states, has no interim appellate agency level that you can get to an appeal decision without having to go to a court. Maryland's different. You go to the commission and then bam, you want to appeal it. You go to a court of law and you argue your case most times to a jury, or you can do a bench trial. But because of that scheme, you don't get a lot of appeals going on in Maryland. So we'll cover. We have about 5 cases. A couple of them we've talked about in the past, but that's the cases that we're dealing with. And Steve, do we want to start with that Tyson Foods case?
We do. No, we do. And I would also mention, if anyone has a question, if you could put it in the Q&A portion, there should be a tab at the bottom of your screen that will allow me to see them. I will do my best when we have a break in the action, and we can answer your questions as we go along. And it does not have to be a question as it relates to these cases we're going over. If you have a question, we will do our best to answer it. As Jack said, my name's Steve Tregay. I practice comp in Pennsylvania, in Maryland, and in the District of Columbia. So I work out of our Baltimore office, our Camp Hill office, and at times our Arlington, Virginia office. Today I'm working out of my home. The first case, as Jack mentioned, is a Tyson Farms case. It's Tyson Farms versus the Uninsured Employers Fund. And to give you a little bit of background, the claimant in this case had alleged an occupational disease to his lungs arising out of raising chickens. The appellate decision we have is about a 30-page decision. The interesting facts are, you have employee claimant who has this occupational disease. He has an employer it's a farm in Maryland, who contracts with Tyson Chicken to raise poultry. And I found it interesting that the Supreme Court had noted that Tyson is the largest owner of chickens in the world, but they do not own a single farm. So the way this works is Tyson owns those chickens that you're going to eventually get in the store. I just assumed they appeared at the store by magic, already wrapped in cellophane. Turns out they have to be grown on a farm. Tyson owns the chickens. They contract with these farmers who own the farms and to raise the chickens. And then they show up, take the chickens, kill the chickens, process the chickens, sell the chickens to everyone in the supermarket. And not only do they contract, they have what they call a broiler agreement, which is how to raise these broiling chickens, the best way to do so. And if you don't listen to the contract, your contract can be terminated with Tyson's. So claimant gets this occupational disease, files a petition with the commission. The commission finds that Tyson and his employer, who parenthetically did not have insurance, so that's really why we're talking about all of this. The farm did not have workers' compensation insurance. The commission finds that Tyson and the farm owner were co-employers of our claimant and grants benefits. Tyson strenuously objects and files an appeal, and it goes to a jury trial, which took 2 days. And the jury found that Tyson and the farm were not co-employers. And I believe that both, and if I say anything wrong, Jack, just correct me. I believe at the trial court, both sides had filed motions for summary judgment, or at least maybe judgment after after all the evidence was presented, before it went to the jury. Both were denied. The jury comes back and says, no, Tyson was not the employer in this matter. It was the farm. Therefore, the uninsured guarantee fund would be on the hook. The fund took an appeal. The Court of Special Appeals looked at the evidence and said, you know what? No, there could be only one conclusion reached when you looked at the evidence, and that was they were co-employers, and more or less the commission was right. Tyson said, we don't agree, took another appeal. And at that point, the court said, no, looking at all of the evidence, a jury could give inferences either way. And that in this case, it was a question for the jury, and the jury, not necessarily properly or improperly, the jury, after reviewing the evidence, found that Tyson was not an employer in this matter. And the court looks at the long established 5 factors as to whether or not someone is an employee. And I will bore you right now and go ahead and read those. The first is the power to select and hire an employee. The second is the payment of wages. The third is the power to discharge. The fourth is the power to control the employee's conduct. And the fifth is whether the work is part of the regular business of the employer. And what the court really said was, looking at all the evidence, and they spend some time going through each one of these elements, because I can tell you Tyson was not paying wages to this individual. Tyson did not have the power to hire or fire the claimant in this matter. In fact, I believe that the underlying contract between Tyson and this farmer indicated, we don't care whether or not you hire employees or not, that's completely up to you. And the contract clearly indicated that the farm itself was not an employee, but a subcontractor of Tyson. Regardless, what the court is really saying here is these questions, if you're going to be in front of when you're in front of the commission, they're dealing with both issues of law and fact. When you get to a jury, they are the finders of fact. And in this case, the finding could be, as it was here, that Tyson was not the employer. The court also said, though, that does not mean that Tyson could never be an employer. This could have gone in front of a different jury, and that jury could have said, looking at all the inferences, we believe that Tyson is the employer, and that jury would have been just as correct.
Yeah, the factors that the court went through and said that they're long-standing factors in Maryland. They're also long-standing factors in other states. It's the principle of hire, fire, right of control, and stuff like that. It's the same thing whether you're in Maryland or Pennsylvania or anywhere else. So the other interesting thing is, because it did go to a jury, Tyson got out of liability, because before the commission, I mean, as in this case, it was found to be a co-employer. And I think in all future cases with Tyson's, with their contract controlling how these chickens are raised and how they're processed and all that kind of stuff, Tyson's going to get nailed. So the only opportunity to get out of this for Tyson is to appeal it to a jury, probably on the Eastern Shore of Maryland, conservative farmers that would allow Tyson to get out of that.
Yeah, we don't, and as workers' comp attorneys, we're not normally, you're talking about, conservative juries versus, liberal juries. It's not something we deal with, at least in Pennsylvania, ever. It's something interesting that you'd have to, deal with it in a workers' compensation case at all. And as Jack said, that's why we don't have a lot of appellate law. I think this was big for Tyson. I think this is definitely something they had to appeal, because you don't want that to set a precedent that they're co-employees. Because every time there's an injury, as that farmer, why would you not join them to the litigation if you're employers?
Well, the other interesting thing is the analysis of this case is to see whether or not they're co-employers, whereas in states like Pennsylvania that has a statutory employment scheme, they don't look at co-employers. They just look to see who has insurance up the chain of command. So have we beaten that dead horse?
Yeah, I don't know. Do you think, I was gonna say, the case probably would not have been found, well, it probably would have been found differently in a state like Pennsylvania, where you have the statutory employer, chain of command, or not. I mean, there's no doubt they were not paying wages. They were not directing what this individual was doing. So it's an interesting case. Interesting. So the next one I believe I have on my list is Greer versus Montgomery County.
Yeah, this is, I mean, I guess the primary interest of this case. And first off, let's talk about Montgomery County. I mean, half the case law in Maryland for comp appeals is filed by Montgomery County. So we have, let's see, do we have any other cases that Montgomery County is responsible? Yeah, we have two cases. So it's Greer versus Montgomery County. It's a hernia case. And the thing, just to remind everyone, that in Maryland, if you have a pre-existing hernia, you have to have, to make it compensable, it has to be an aggravation that requires immediate surgery. And in this Greer case, I believe the diagnosis of the hernia was in July 2015, and the claimant didn't undergo surgery until December 2016 for alleging an aggravation. He tried to get over that limitation in terms of aggravation that requires immediate surgery by claiming it was an occupational disease. And basically the court said you can't do that. You have a specific statutory provision covering hernias, and therefore he's out of luck.
How immediate is immediate, Jack? Have you seen any cases in which are we talking, I'm lifting a tire at work, I feel a pull, and I have to have surgery within 48 hours, or is it within a month? What is it, or is that a case-by-case basis?
I think it's case by case, but I've seen them like a month out where they're trying various things and then basically undergoing the surgery.
So you can't let a year go by like the guy did in this case and say,
oh no.
And again, that is different in something like in a state like Pennsylvania, in which any aggravation of a pre-existing condition can be found to be a work injury. Just tell you just have a doctor testify, yes, he had a pre-existing hernia, but this lifting incident made it worse. So in Pennsylvania, it could be 2 years in between diagnosis and surgery, and you could still be on the hook.
Let's see.
Baltimore City. Baltimore City versus Ulrich. It's Ulrich. This is an interesting case. This is not to put everyone asleep, it's a subrogation case. Just stay with me. I know that they're not the sexiest workers' comp cases in the world. The claimant suffers an injury to his elbow while lifting at work. He then goes the next day to Concentra for treatment. They diagnose the claimant, shockingly, with an elbow strain. You strain, have some ibuprofen, put some ice on it, get back to work. He returns to work with restrictions, is not getting any better, continues to have pain. 5 weeks go by, he goes to, I'm gonna guess it was an orthopedic surgeon, just a specialist here, who diagnosed the claimant with a complete tear of the biceps tendon, for which he needed surgery. So he stops working, he undergoes surgery, but then post-surgery, he's not getting any better. He's unable to perform his job duties, and then retires on disability. What happens next is claimant files a malpractice claim against Concentra. And what's interesting about the malpractice case that is filed is that the claimant says, I'm not looking for medical expenses from Concentra. I don't think what Concentra did caused the need for surgery. Instead, I needed the surgery sooner. And I believe in the discovery portion of that third party action, the expert claimant indicated that had he had the surgery quickly, he would have had a better result and could have gotten back to work. But the delayed repair resulted in decreased strength and endurance, and claimant couldn't do the job he was doing before. Again, counsel did not ask for payment of any medical bills. They settle the third party claim. The amount of settlement is larger than any wage loss or medical that's been paid on the workers' compensation claim thus far. The employer says, we want all of our money back for both medicals and the wage loss. Claimant's counsel says, nay, I am not giving you any money for the medical portion of this. And I believe he would only satisfy, or said he was only going to satisfy the indemnity portion, the indemnity benefit portion of the lien. The commission found that the employer had not presented any evidence of what additional medical care was required due to the negligence of Concentra. And on appeal, the employer says, no, the act is clear. We should get all of our money back. It is I believe the law, it is the employee shall reimburse for any amounts paid for medical services. And as we know, appellate courts love to look at the word shall and be able to interpret it as may. And that's what they did in this case. What they said is you need to look at what additional medical treatment would have been caused by that misdiagnosis by Concentra. And the court in this case said they did not ask for any medical benefits from that third party, and therefore the employer cannot get any money back with regard to medical treatment from that third party, because that would actually be, I believe it would be not double dipping for the employer, but it would be more or less I don't want to say unjust recovery either, but something that they're not entitled to because they didn't have to pay for anything. That third party didn't cause the need for that surgery. It was the work injury that caused the need for the surgery. I'm getting that right, Jack?
Yeah, and that's this is the same thing as, subrogation in Pennsylvania as well. You have to, it's the employer's obligation to have a medical opinion on what portion of those medical bills were related to the negligence of the medical provider. And in this case, there was no evidence presented, and I suspect they couldn't have presented any evidence that any additional medical care was required due to Concentra's negligence, because the whole basis of the third-party medical malpractice action was that Concentra didn't provide the care as quickly as necessary. So,
yeah, and it looks like other than probably ice and have some pills, they didn't do anything. Period. Yeah.
But again, if this was, let's say, a medical provider, trying to think, someone fell off a table and injured a back when they're operating on a neck or something like that, the employer would have to provide a medical opinion unless it's obvious that these bills are a result of this additional injury that occurred due to this malpractice action.
Correct. Yeah, especially if they fall off the table or injure their back and then need surgery for the back. It looks to me like the negligence there of having them fall off the table is due to that back surgery, but the original neck surgery was not necessarily related to that negligence.
And if anyone wants the sites on this, we can put those, send them to you. You can just tell us in the chat if you want the sites for any of these cases.
Yeah, absolutely. Yeah, that's not a problem.
Because this stuff it's not like it's amazing stuff or anything. But before we started today, I think the last case that we're going to talk about is one that we've addressed in the past, but that's the only sort of amazing case of any of these updated cases.
Well, yes, I agree, and it's relevant to our current stay-at-home, work-from-home sort of environment that we're in.
But picking off and Montgomery County, another Montgomery County case versus Fernando Rios. This is a case where Montgomery County, I guess, felt that the injured worker, filed for worsening before he had an IME demonstrating that he had a worsened condition. And so in order to go for worsening benefits, additional permanent impairment benefits, you have to file for worsening within 5 years from the last payment of compensation. So in this particular case, the injured worker filed for worsening within the 5 years from the last payment of compensation, but then didn't get an independent medical evaluation demonstrating that there was a worsened condition until after the 5 years. So Montgomery County was arguing that it was untimely and to throw it out. And in this case, the court said the claimant doesn't need to get an IME timely it just has to file for worsening when it has a basis in fact. And Steve, if you can tell me what a basis in fact is, then
My back hurts worse than it did before. Can you get me more benefits?
sure.
I guess, I mean, that's the only thing that it could be, correct? I mean, if you don't have a medical opinion prior to filing that petition, it has to be my symptoms are worse, and it has to be as a result of the work injury. I guess that's it. That's our basis of fact.
And actually, I have a hearing tomorrow where it is untimely. So,
Oh, really? So it was actually filed. It was actually filed late.
Yeah, the original award was paid out more than 5 years
Okay.
from the filing of the worsening condition, and it was like 2 or 3 months. But I raised the limitations, and I'll be moving tomorrow that the issues on worsening be dismissed as untimely. So now we get into something, at least in my view, is a little more interesting. And we've talked about, it's the course and scope kind of issue. We have 2 cases that are going to talk about that. One, it's almost like nostalgic pre-COVID case, and that's Schwan Food Company. And I don't know if you want to talk about that, Steve, or not.
Yeah, I can. I'll talk about the facts a little bit, then we can sort of discuss, variations on a theme as to what we think, if we change the facts, will we get a different result sort of situation. This is actually a case where the claimant worked for Schwan Foods. He worked for Schwan in Maryland. Maryland did not have, or Schwan did not have, any office in Maryland. So he did not have any set working hours. He said that he did testify at trial that his morning would begin at his home, quote, as soon as the phone started ringing, really. And he indicated that people would start calling him at 4 o'clock in the morning because that's when they were available. And his job was actually to go, he used a handheld computer, would download his route for the day. He would have to go and meet with delivery drivers and receive inventory deliveries for each of his accounts. So his job was, and I believe he had Wi-Fi at home, which he would use, which is this handheld device was Wi-Fi enabled. So he would use his Wi-Fi that he paid for, but got a discount on, and Schwan's was an employer discount on it, and that the employer was aware that he was getting a discount. He would use his own car every day to go back and forth from the stores. Schwan's did pay for his mileage, except for his first drive so wherever he was going from his home to the first store, they would not pay that mileage, but he would then deduct that from his taxes as a business expense. The injury occurs when I believe there was a pretty bad snowstorm the night before. He wakes up, downloads his day for the day onto his little handheld computer, needs to take his son to daycare, which is, if I'm remembering correctly, about 3/4 of the way on his way to the first store. As he's getting ready to get into his car, he slips on black ice and hurts his leg. And ultimately, what the appeal court found that he was in the course and scope. And Jack, why, so I can stop talking, why did they find that he was in the course and scope?
Well, this is they came up with a rule on when an employee's home qualifies as a work site under Maryland workers' compensation law. And there are 3 indices to determine that. And one is the quantity and regularity of work performed at home. 2 is the presence of work equipment at home. And 3, the special circumstances of the employment rendering it necessary, not merely personally convenient, to work at home. And under the last prong, the court said the fact finder should also consider whether the employer acquiesced to the employee's use of his or her home as a work site or reasonably should have known the employee was regularly using the home as a work site. So that was like nostalgic looking at what a home work site would be before COVID.
Or COVID, and and I think I'm incorrect when I was talking about the posture of this case. I believe that the appellate court sent this back down for additional findings of fact. Correct?
Correct.
Yeah, that's my mistake. And do we know? I was trying to do some research on it. Do we know where we are? Maybe the case settled, and that's that.
I don't know what you call it now, but I shepherdized it, and there's nothing
Right.
further on it.
Okay, so we don't know where we are.
That's what.
I'm sorry. Go ahead.
Oh no, I mean that's sort of to segue into what is a home office. I mean, we had, I guess about a year and a half ago. Let's see. I think I got a question to restate the 3 factors in determining whether a home office qualifies as a job site, and it's the quantity and regularity of work performed at home. That was the first one. But we were talking before we started today, and we did a little bit of this with Jim McAllister in about a year and a half ago, talking about the scope of what is a home office. Is it a room? Is it a desk? Is it a structure? I mean, that's what I guess I have these ear set that I can't answer my phone unless I'm sitting here with the ear set. So I'm thinking maybe my home office is my little table with a computer on it, and I have an ear set on.
It probably is. And in this gentleman's case, the quantity and regularity of work seems to me that he was doing a lot of work from home well, at least, I mean, I guess you should use the word a lot, but every morning he had to use his home Wi-Fi to be able to download what he needed to do for the day. It was more or less his home base for operations. I mean, and I think it hurts the employer in this case that they had no physical place of work in the state of Maryland. And I think also one of the facts is they would send him marketing materials, stuff that was so large he couldn't keep it, couldn't even keep it in his car. He had to keep it in his house, and he was specifically not allowed to keep any materials at the stores that he would visit. So it all had to be kept in his house.
So, as a traveling employee in Pennsylvania, this would be compensable. We wouldn't be getting into these.
No, we wouldn't even be getting into it without a doubt. He was getting into the car to go to the first. I think dropping your, in Pennsylvania, we would look at it. First of all, he didn't even make it. It's not as if he was injured at the daycare facility where he was dropping his son off. He never even made it that far. He slipped and fell on his way to get into his car to get to that first store. And regardless of whether or not he was going to make a small detour to drop his son off, which I think even in Pennsylvania, that wouldn't be enough to take him out of the course and scope. So we may not, so frankly, in this case, we may never know what happened if the parties ended up resolving it before it went back down. We don't know how it would have turned out. But I think it was sent back down more or less I think they would have found that he was in the course and scope. I just do, especially, and now with what has happened since COVID, when an employer decides you must work from home, we are not going to open our office. At that point, I think it becomes a very factual. It becomes a factual determination as to whether or not you're furthering your employer's interest when you're working from home. What were you doing when you were injured? Am I sitting here dictating on a case and I lean over too far in my chair and I smack my head? That's probably compensable because I'm dictating that letter when it happens. If I'm doing laundry down the hall and I hurt myself while I'm, taking the laundry out of the washer and putting it in the dryer, am I still in the course and scope, Jack?
That's right. And the other question I had is, if the employer has a vaccine requirement in order to work in the office, and if you're not vaccinated, you have to work remotely. Does that help an injured worker who's injured at home, or does that hurt an injured worker who's injured at home?
I don't know. I think it might, at that point, maybe we're getting into the reasons that you're not vaccinated. I'm not vaccinated because of an underlying health condition and I have to work from home, or I'm not vaccinated because I simply refuse to get vaccinated. I don't
And
know.
yeah, I suppose that's the case, and whether it's fair to expose the employer to additional risk for at-home injuries when the individual has the option of complying with the employer's requirement that one be vaccinated in order to work in the office. So those are some of the considerations. So Steve, do we want to talk about the last case? Is another Montgomery County case?
Shockingly, another Montgomery County case. Can you want to take the facts of this one?
Sure. In this case, it was a firefighter living in Virginia and working in Rockville, Maryland. And his employer, Montgomery County, asked him to participate in a 2-day recruiting event at a training facility near Gaithersburg. And so it ended at 8:30 p.m. the first day and started at 6 a.m. the second day. And so rather than go back to Virginia, the firefighter chose to go to a nearby fire station in Potomac, Maryland to sleep for the night. And so he went to this, it wasn't the closest station, but it was, he called a slower station so he could get a better night's rest. But he got up in the middle of the night and he stumbled over something in the dark. And so the court got into a bunch of discussions on how an injury, when he's sleeping somewhere that he wasn't required to sleep and injured himself at night when he got up to get a snack or whatever, how is that in the course and scope of employment, Steve?
Well, yeah, and I don't think it was, but the court found differently. And of course, as always, we have requirements. So for an injury to be in the course of employment, the standard is that 1, it has to be during the period of employment, 2, at a place where the employee reasonably may be in performance of his or her duties, and 3, while fulfilling those duties, or engage something in an incident there too. The court says you don't have to have all 3 of these. You can have one of them. It's not necessarily a complete rubric where you need all 3 to be able to find that the injury was in the course of. The court found that since off-duty use of the bunk facilities was permitted, and on-duty firefighters also use the bunk facilities, a fact finder could find that the injury occurred in the course of the employment. And the court concluded that the trier of fact could reasonably determine that the claimant was engaged in an activity related to his employment, because although he admitted he stayed at the station because it was convenient to him, it was also convenient for the employer. I'm not sure. I mean, so ultimately, Jack, it seems like a case to me where they wanted to find he was in the course, that he was in the course and in the scope, and they were going to find a way to do that. Because I really think this is bad case law. I do not think that he was in the course and scope. Just because he decides on his own, I'm going to go sleep somewhere where it's quiet because I don't feel like driving home. I'm not sure how automatically that makes it better for the employer the next day. And again, I don't know what evidence is presented that it somehow made it easier for him to get to the station he was supposed to be working at rather than coming from home. That's just, I'll get off my soapbox, Jack. That's just the way I'm looking at this case. I just don't like it.
Well, I mean, I think it, as we were stating before we started, it sort of throws out the rule, the time, place, and circumstances requirement for work injuries. And there you have this guy sleeping somewhere he wasn't supposed to be or required to be outside of the hours of employment. So it's just a little.
I think all it's going to do is hurt, at this point, don't be shocked then when your employer says, no more sleep, if you're not on duty, you're not in the bunkhouse. Yeah, that's
it's Montgomery County, so maybe they did do that.
Well, and I think that's important. And speaking of work, again, getting back to the home injuries at home, we were discussing this before, where how do you limit that? As an attorney, I don't have set hours either. I mean, I'm always available between time that you would expect a business to be open. But Chartwell doesn't say I have to be sitting chained to my computer from 8 in the morning till 5 at night.
We don't know that, Steve. I mean, Chartwell gave me these earphones or something, so I don't know if I get up and take my earphones off, whether I've just left my workstation.
Well, it perhaps, in fact, maybe an alarm goes off somewhere. I don't know. I've never received the guideline, but I'm certainly, I think the more people work from home, the more you need rules, such as if you are working from home and you are doing our business, you are not, you're not doing laundry. You're not cleaning the house. You're not putting together that piece of IKEA furniture that arrived this morning. You are working for us. I think you need to be more rule intensive to say, hey, they were doing something we told them specifically they weren't supposed to be doing.
Well, it's almost like the requirement, I guess, again, maybe it's nostalgic when we used to pick up a phone when we're in the car, and employers would have rules against that.
I don't blame them. I knew defense attorneys, not me, it's not me, that would drive, dictate, and I've seen people have files open on their dashboard while they're driving. I mean, I have never done that. I won't say that I've never dictated while I drove, but never was I reviewing a file I was attempting to drive.
I've never ordered a full-size transcript because the miniature can't be ridden or read behind the wheel.
No, that's true. It can't be.
Well, we finished quite early because Maryland doesn't have a lot of case law update.
If anyone's interested in a puppet show, we could do that. We are. I'm just trying to think. There was no other. There were a couple cases that we threw out that just were not relevant, and I don't think very interesting. But if anybody has any questions, otherwise, I guess we will end early today.
And they're all Montgomery County cases anyway.
Why does Montgomery County get all these appellate cases, Jack?
One doesn't know, but I mean, private employers haven't been able to file so many appeals in Maryland.
True.
But I don't see that there are any additional questions. And so we may wrap it up and thank everyone for participating. And if you want the sites or any other questions about these cases or any other topic, just let us know. There is something in the Q&A though.
Yeah, there is. In the Subro case, did the employer get all the indemnity back or only the indemnity related to the med mal?
I believe the employer got the wage loss benefits back, the indemnity portion.
Correct. And it would have been all of them. It wasn't just that was related to the med mal.
It may have, well, we could go back and look at it, but they're not going to get anything that happened before the med mal.
Correct.
So the med mal was Concentra. I suppose that would have been early on in the claim. So let's say that probably was early on in the claim. And so they probably got all their indemnity. If it was like a surgery that was the medical or the negligence that happened 3 months after a work injury, you wouldn't get anything before that, but you would after the negligence occurred.
Correct. And in this case, I think it was the next day. It was the day after the injury went to Concentra. So they would have gotten it back.
Mm-hmm.
So. All right. Well, then with that, I will say have a great day. If you have any, at the end, our contact information should be on there. If you need anything or you have any questions, always feel free to email us or call us. That's what we're here for. That's
right. And some of you, well, I haven't seen lots of folks in a long time, so we'll just say hi and hope to see you post-COVID some point.
Absolutely. I hope that I'm still working by the time that we're out of the pandemic. So take care, everybody.
Yes. Thanks a lot. See you next time.